I'm Matt Gishard, and this is No Holds Barred. In this episode, we're going to talk about arbitrations, mediations, and settlement conferences, and what the differences are among those three. Arbitrations, mediations, and settlement conferences. The goal of all three to resolve cases prior to trial. Interestingly enough, in most cases we think of arbitrations and mediations in civil cases. In criminal cases, we oftentimes talk about a settlement conference. All three relate to civil cases. Rarely would you ever think of a mediation or an arbitration in a criminal case. But let's just talk about a system. Let's talk about the civil system in the state of California right now. I want to say there's a reason why we don't have all the cases going to trial that we used to in the civil realm. And why is that? Because of arbitrations, mediations, and settlement conferences. But mostly because of mediations. So how it works is somebody files a case against another. They answer, there's discovery, lawyers are involved, and they get to a certain point where they show up at a case management conference and the judge says, all right, how's everyone doing? How's the case coming along? Well, Your Honor, we've almost finished discovery, we're in this. All right, what I want you to do is mediate the case. And it says, all right, because I'm not going to give you a trial date until you mediate the case. And we hear that all the time from judges, because they want people to get involved in some process of alternate dispute resolution. That's what oftentimes we call it. Alternate dispute resolution. Can be arbitration, mediation, or settlement conference. That is something short of trial. What is the difference between each one? Well, an arbitration is a hearing. An arbitrator listens to the evidence, receives briefs, doesn't talk to the parties ahead of time, just like a judge, and renders a ruling. Now, it can be a binding arbitration or non-binding arbitration, and the parties agree to that. And I want to say a number of years ago in the civil courts in the state of California, everyone was forced into arbitration. And it was this judicial arbitration where people were forced to go to arbitration, and honestly they kept their powder dry and didn't give half of their evidence in their briefs because they know they were just going through a process, and they didn't agree that it was binding, so it was non-binding. As it turns out, everyone appreciated after a period of time, it was a colossal waste of time. A colossal waste of time. It was just one more process that didn't move the ball closer to the goal. So arbitrations are very good, and oftentimes we hear about binding arbitrations in employment agreements and various kinds of things where the parties ahead of time have agreed that if they get into a dispute, they will go to binding arbitration. And that is binding. And that means whatever the arbitrator rules, that's it. And rarely is there an appeal from a ruling in an arbitration. Possible, but rare. What is best, of course, is a mediation. It is voluntary. The parties choose a mediator. In some courts, and most in the state, and particularly Contra Costa County and others, there is a panel of arbitrators, and the first, in many cases, 3 hours are free. And that's a mediation process through the courts. So many people choose that and go essentially put the case in front of a mediator. The mediator can talk to any parties. There's no conflict issues related to talking to one party. And very good mediators, in my view, will seek briefs from everyone 4 or 5 days ahead of time, call the parties separately, discuss the case, and then get into the mediation process. Sometimes they jointly meet with all parties and that means the parties themselves to the lawsuit plus the lawyers. The judge kind of talks about what happens here is confidential, whatever you say here, and it can't be used later. If this case doesn't settle, you can't use what we talked here or what offers or demands were made here later on. It's all stays here. And the idea is to try to resolve the case. And I want to say, arbitrators don't have skin in the game other than they want to settle the case, and they get paid for it. So if it's that court-ordered mediation where the first 3 hours are free, but many times it goes well beyond those 3 hours, that mediator gets paid. In a number of cases, the mediator is hired from at the outset. There's some very good mediators, and we think of JAMS and ADR and all these different groups that do nothing but mediations and arbitrations. I say no skin in the game in the sense that if somebody makes a demand and the other side is willing to pay, the mediator doesn't jump in and say, oh, I don't think you should pay that. Look, if somebody wants to pay for something, somebody wants to accept something, the arbitrator's job is simply to make the parties agree. Arbitrations are very good in that sense because they're more informal, and sometimes they can extend on. So let's say the mediation has gone all day. There have been discussions. They're getting close, but not quite there. And the mediator, and I've acted as a mediator oftentimes, will say, look, let's all adjourn for the day. I know we'd like to get it all done today. I don't believe it's going to happen today, but sometimes people go home and sleep on it. Let's do it by phone for the next couple of days, and I think we can get it done. And oftentimes that happens. So as we jump back to when I said that judges oftentimes make you go to mediation before they'll set it for trial, there is a real incentive. Why is there an incentive to go to an arbitration, a mediation, or a settlement conference? What's important about that? Well, I want to say jury trials are very expensive and very time-consuming and very nerve-wracking. And so going to trial, you have typically a jury, and people don't know for certain what is going to happen. If you resolve a case through a mediation, you know for certain. And people, a funny saying, people often say, what's a good settlement? Well, a good settlement is something where one side thinks it paid too much and one side thinks it got too little. So meaning there was a compromise, the parties compromised, they got the case off their desks, the case is resolved. What's a settlement conference? Well, oftentimes some parties say don't want to go to mediation, don't want to have anything to do with it. The judge says, well, I'll tell you what then, you're going to come to a mandatory settlement conference at my chambers. So you're going to come to court. I want all the parties here. I want the insurance companies, if insurance involved, I want them all here in my courtroom on X date, and we'll have a settlement conference. I'll bring in another judge here. So you could see about the potential conflict is a judge sitting as the settlement judge, and we see that a lot in cases that are assigned for single purposes to single purpose judges. And you can see where there's a potential conflict, because if you have a settlement conference and one side is pretty stubborn and doesn't settle, and then the case proceeds to trial in front of that same judge, you can see where there's a potential problem there. That judge may, hopefully not, but hold a little bit of a grudge about that. So that's why many times at a settlement conference, a separate judge is brought in than the judge for all purposes. So, and the settlement conference, and they kind of hash it out. Now, I say as to settlement conferences, there's nowhere near the time that the judges have to handle that settlement conference as in a mediation. So again, I'm going to say the best is absolutely a mediation, because it's outside the court system. It's a neutral mediator. It can take all the time in the world. They can take several sessions. The litigants are paying for that, whereas a settlement conference is generally, that's part of what you pay for as taxpayers. The judge is getting a salary, but there's not enough time. Typically, the judge doesn't have enough time to put into really trying to resolve the case. So resolving cases is critically important. That's what we like to see, and that's why mediations are are so important. And I have to say that the number is incredibly high, something like 90%, 99%, something like that, of cases actually resolve through mediation rather than through trial. Very, very few cases nowadays, percentage-wise, actually proceed all the way through trial. And they often say, do you want 12 strangers whom you don't know deciding your case for you? Or would you rather have discussions, your lawyers present, with a neutral mediator, and getting the case resolved in that fashion? Or resolving the case through appointment of an arbitrator and agreeing that it's binding. What if it's not binding? So what if there's an arbitration hearing? You go before the arbitrator, you have the hearing, the arbitrator issues a ruling and it's not binding. You say, well, okay, now the case proceeds to trial. So you're kind of back in that same situation. In my experience, honestly, what often happens is after that, the parties then mediate. After a non-binding arbitration, they mediate and the case then resolves, or in some cases, actually goes to trial. So I want to talk a little bit about how that all works, and I want you to kind of understand why it's important for people who are involved in the civil system to appreciate why mediations are important, and honestly, highly recommend it. Much less costly. Give you a little example of how costly things are. Cases in which there's, say, an automobile accident and you need to hire a human factors expert, and that says, well, I charge $10,000 a day. And then you need the orthopedic surgeon that actually saw you, and that makes sense. Rather than hiring an outside expert, have the doctor who actually treated you. And the doctor says, okay, well, I'm going to have to charge $10,000 a day because I have to give up my practice for a day. And so the human factors person and the accident reconstruction person says, okay, I'm going to charge $10,000 a day. And the doctor says, I'm going to charge you $10,000 for the day. And let's say you go right up to the day of trial and the judge says, I can't get you out today. But all three of those experts already canceled their days, incurred that cost, and guess who incurred that cost? You did. So in many cases, you didn't get out to trial and there's $30,000 in expert fees or more. And so the case is continued to another date and your hair is catching on fire because you're just seeing these incredible costs going up. To say nothing of the lawyer's costs, the costs jurors cost. You have to pay jury fees. You have to pay court reporter fees. There are a number of things that you have to do. So trials can be incredibly costly. And then again, at the end of it, 12 strangers are going to decide this case. Fortunately, in our sophisticated system, in most cases, they get it right. But in some cases, just enough that we've heard about that, I'd rather go to a mediation and have the kind of certainty of an agreement, the money, how it's going to be paid, when it's going to be paid, and the case is over. And that makes complete sense. So that's how our system of alternate dispute resolution, arbitrations, mediations, and settlement conferences play in our civil system. If you like this episode of No Holds Barred, hit the like button and hit the subscribe button. It helps with our YouTube algorithms. And again, if you have any comments about this, please enter them below. I read them and I'll respond at some point in a future No Holds Barred episode.